the
I know,
evidence.
counsel, and again, the burden for doing that is on the attorneys, not the court.
Right.
I'm getting tired of doing attorneys' work in a trial, okay? Jury instructions are the providence of the attorneys. Jury instructions I asked on 4 separate occasions to have them done with a stipulated group and a proposed group. I had to get you guys here 3 separate times asking you to do the exact same thing, and we still had to go back in chambers and I had to rewrite them. And now I don't even get verdict forms that are proper, and I've got a jury coming here in 10 minutes. Counselor, the plaintiff, be prepared to close.
Yes, Your Honor.
Go ahead.
Thank you, Your Honor. May it please the court, members of the jury, quite humbly and personally, I'd like to thank you for your time and your attention to this matter. I've done a couple of jury trials. This is the first time I've ever spoken to a jury on behalf of myself. And I want to thank you. I know that it is a sacrifice, and we appreciate your service, and I appreciate your willingness to serve the community and to aid and assist in this matter. We believe the evidence has been presented to you quite lengthy, and that you were forced to endure a great deal of the evidence and able to look at it and see it up above there on the screen, and were able to evaluate it and see it and to make a determination as to the credibility of those that have testified and the persuasiveness of the evidence that you've heard. You've heard the testimony of several individuals that have come before you and that have made statements and have testified. The proof and the evidence has demonstrated that, obviously, and you know the facts, that there was the contract and thereafter there was this transition period. And the testimony that you've heard on behalf of my case is that transition period couldn't happen soon enough, and that there was a need to make a change there very quickly. And you heard the testimony of Mr. Del Casal here today, who said he was practicing the unauthorized practice of law, that UPL that we talked about in the bar complaint that he filed against me. He's admitted that he was doing it. And those caused concerns. And he needed to go, and that time came, and he went. But it's like that old adage where you can leave the place, but you can't leave the place alone. And that's kind of what happened here, that he left the location, but he couldn't leave the location alone. And he continued to meddle, and you saw the evidence, you heard the testimony that was ongoing, and some of those things, those posts and some of those things that were ongoing. And again, we don't need to go through all of that. That culminated in what I call the big one, I guess. Before that, it was the bar complaint. You had the opportunity to review that. You're going to have the evidence with you. In the jury room, you'll be able to look at that bar complaint. You'll be able to compare that to the published website. You'll be able to see that. And you'll have the ability to review that and to make those comparisons and those contrasts. Pretty much everything that was going on with Mr. Del Casal at the business was essentially what he accused me of in the bar complaint, which is quite ironic and a bit of gaslighting on all of us, that I'm not doing those things, you're doing those things. And that seems to be what the defendant's theme was throughout everything, was really to blame me for everything that happened here. And you heard multiple blames going out. Testimony was that I complied with the contract fully. Mr. Del Casal did not turn over the website to me. He never turned it over. I think that the defense there is somehow, well, you never asked for it, so therefore I don't have to do it. And you heard that from Mr. Franklin as well. It's not my burden of proof. So you need to go find these things. I don't need to help you with that. Mr. Del Casal has the same attitude with you on the stand here today. I'm not going to turn these people over to you. I'm not going to tell you who they are. That's your problem. That's your burden of proof. Well, that's just not the way that it works. Because you have that jury instruction there that states that if you withhold evidence or you destroy evidence that would have been helpful to the other side, you, the jury, get to construe that to be adverse, which essentially means in English, any evidence that they had that they didn't present, that they could have, you can look at that and say, that would have been bad for them if they would have come up with it. So rather than sitting there and blaming me and saying, we didn't need to produce it because that's your burden of proof, well, that essentially by our law says, and the jury verdict, or the jury instructions that you have, you can deem that to be adverse to them. You can say that must have been bad for them, or else they would have turned it over. And you didn't hear one testimony from one independent person, and you didn't hear one disgruntled customer come here and testify, and they couldn't even name one. Couldn't bring one person in here, and you saw the evidence yesterday that Mr. Franklin, he even posted a poll online. He was thinking maybe I'll recruit some people. Couldn't even come up with one individual who was dissatisfied. Am I perfect? Oh no. And have I had some disputes here and there? Absolutely. That's the nature of business, and it's the nature sometimes of doing family law, and it's the nature of being a bloodsucker and being an attorney. That's, you just kind of comes with it. Sometimes you're going to have some problems with people, and no, I'm not perfect. And I hope that I didn't come off that way, that I thought somehow that, that I was above everything, because obviously no one is. And I'm no exception to that rule. But I have made every effort, and you heard every testimony that every effort was made to be compliant, to follow the law, and to run a good business, to run a tight ship, to make changes that were necessary, and to also make money and be profitable and help others all at the same time. And all that testimony you heard. You heard these other witnesses come in here, and you were able to hear them and hear their opinions and to hear those things that they've observed, and some of the benefits they've received and some of the distractions they've had in their business. And I appreciate you thinking about them, because they are part of this, and they are members of my firm, but I look at them as members of the family. It's a hard thing to file a lawsuit in your name, because it's really a family, it's really a lot of people, it's a lot of people who are dependent upon that, and they all have some kind of interest in this outcome, and are very concerned about the health and welfare and the ongoing ability to continue the business. Now you have several instructions about several causes of action, and I just want to hit on them really quick. That you have the corporate theft, and we believe that to be very significant because that web traffic, and we had some very interesting questions on that, about that hyperlink off of the Google landing page, taking that over and essentially stealing web traffic, taking away the traffic of potential customers and individuals who are looking for me. And can you imagine being a business owner and having your business advertised on Google, and when they click on the button to go to your website, you have this horrendous defamatory site that's just blasting you. And the confusion of a customer to go there and see that, or confusion of a client when they see that, what could happen in somebody's mind. Mr. Franklin testified here today, never really gave it a thought, never really cared. He was just kind of reckless, wanton, willful, never even had any regard at all for those he was harming and what he was even doing. And one would think he would have considered that just slightly. We believe the elements have been met quite clearly there, that there was damage done, and it was wholly malicious, as you'll be able to see there. It was just done without any care or concern for others, and as he stated to you under his oath, he didn't know whether it was true or false. He didn't know anything about it. He didn't know anything about me. And so it was malicious. And it was malicious by his own testimony. And we were damaged as a result of that. You heard Cam's testimony yesterday, or day before, sorry. Maybe yesterday. Anyway, it's been a long week for you, I'm sorry. But phones stopped ringing. People stopped coming in. Things got kind of quiet for a little while. It caused him to go online to find out what's going on, what's happened. So it had the effect, and it had the very effect that Mr. Franklin wanted it to have. I love the question that we got from you about, did you get paid to do that? Did the customer even ask you to do that? Did you even consult with the client? No, he didn't, not at all. He just did it. And then he said, well, it was only up for 24 hours, but then later on, when confronted with the fact that he republished it again on the 18th, which was essentially 6 days later, oh no, that's it, I just published a page that said under construction because somehow I was going to get paid if I did that. It lacked all credibility. and it can be disregarded. With regard to the breach of contract, you've heard all the terms of the contract. You're able to see that, but the website just didn't get turned over to me. And again, their defense is, well, you never asked. But whether I asked or didn't ask, it didn't give Mr. Del Casal the right to use it, and didn't give him the right to defame me on it. And they knew darn good and well what they were looking for when they went to look for it. They knew what they were after, and they knew what they were doing, these two individuals, because they conspired together, the two of them. There's no question about that. It is a combination of two or more individuals acting together to harm me and to harm my business, which caused damages, lost profits, and it caused harm to my business reputation. And you saw so much evidence that linked these two individuals together, posting online, posting about each other, posting about me, reposting Google reviews, posting again and reposting. We don't need to go through that anymore. It was painful how much there was, and you didn't see all of it. It's just that we had seen enough, that there's no question these two individuals worked together and they were in concert with each other when they made this plan. They disparaged my business, it was done with malice, and damage was received. And you heard the testimony about the damage, and you as the jurors, you have the discretion and the judgment and the wisdom to determine what amount of damages those should be. And I look to you on that. Because there's really no set law on how you calculate damages. It's what you believe to be appropriate and fair. Finally, with the cause of action, the defamation per se, which is really kind of an interesting cause of action, because in that particular cause of action, you look at that and you look at these statements and you make a determination about whether you think they're false or offensive or wrong or untrue. And you have the opportunity then, if it is about my trade or my business or my actions as an attorney, words like untrustworthy, dishonest, corruption, extortion, those types of things about a person in their business. Again, going back to the pizza parlor example, very different to say it's not good pizza or I just don't like the pizza that I got there. Much different than saying they're corrupt, they're criminals, they stole my money, they didn't give me my slice of pizza. It's a whole different realm you're in there, and then when you make those statements that are untrue with the purpose to harm, or negligently even make them, like Mr. Franklin said, I didn't know the difference one way or another, didn't care, I just wanted to get paid, I put it online. If it's damaging enough, you can just presume damages, which essentially is, you said that about a business, it's not a good thing. You shouldn't have said that. You know people aren't going to want to go there. And we just have to presume that that's harmful. And you don't necessarily have to presume damages, or we don't have to prove damages. It just is in and of itself damaging. When you think about a business having those things in there. A bank steals money. That's defamatory. Nobody wants to put their money in a bank that's going to steal their money. And so if somebody says that about a bank, immediately I go to defamation because I trust a bank. I think that's somewhere I can put my money. And you look at that in that sense in the context of defamation per se, and that's really what we're talking about there. And I think it's been very well proven for you. A couple of things else that I just want to touch upon with regard to the publication on the website. And I talked about this in my opening a little bit. A brick is not a wall. I understand that. A brick is not a wall. But you heard testimony about so many bricks that we dealt with here. And you heard the testimony, him making comments about my stepson, things that only Ernest Del Casal would know. Using the word typist over and over again, using the word unauthorized practice of law, talking about the history of the company. Brick, brick, brick. Information about Scott Cater that no one else would know. Brick. Information about George Boyer that I didn't know. And I don't even know how anybody could know that. And Franklin, for him to come in here and testify that in casual conversation somehow he heard that around the office there, that's not true. Another brick against them. The information that Arturo was left off of both the website and the publication, a very suspicious brick. Some of the statements about me personally and taken collectively, all these bricks form a wall of evidence which cannot be overcome or cannot be brushed aside. As you heard in the jury instructions, the burden of proof is the preponderance of the evidence. And when you look at the preponderance of the evidence, well, before we get to that, when you read the website, I just want you to consider, Instruction 28 says, in deciding this issue, you should consider whether the average reader or listener would conclude from the language of the statement and its context that Mr. Del Casal or Mr. Franklin was implying a false statement of fact to be true. And to think that somehow that website doesn't implicate or imply that it's true when it's titled The Truth, I don't know where you get anywhere else with it. It's wholly false. There are maybe an element here or there that somehow factually had some kind of truth somewhere at the root of it, but the implication and the tone is wholly false, and it presents the wrong idea, the wrong information. Again, there's a wall of evidence which they cannot get over. The preponderance of the evidence is 51%. It's one feather more than 50%. It's more likely than not. You can put it any number of ways you want to put it, but it's just slightly more probable than it is less probable. The burden that you have to come to is it more probable, more likely than not, that Mr. Casal was the author of this? When you look at all the bricks, and when you look at the wall that's been constructed here that you've listened to and you've heard, and all the evidence that you've seen, it's very hard to deny that defendant Del Casal is the author. And of all people and all publishers, it's his friend, I guess, Michael Franklin. There's some dispute about whether they're friends or not friends. Who knows? Maybe they became friends through this litigation. I don't know. But what a coincidence. And coincidentally, they had a phantom that they cooked up. And coincidentally, none of his information can we find. It's gone. Everything has vanished. And we're not going to provide you any information, and we're not going to come here and submit any evidence, but we're just going to say, you have the wrong people, we didn't do this, and there's nothing wrong with what we did. And that's essentially the defense you've heard. In summation, I ask you just to consider this from my point of view, or put yourselves into my shoes. That you have a business that you care very much about, and very many people depend upon that. And you get a website and you see something like that about you, and about your child, or about someone you care deeply about, or people that depend upon you and rely upon you. And you see that, and what would you do? And how would that make you feel? And what action would you take to correct it? And what would you do to help those around you so that they were not damaged and harmed by this? I would submit to you that we've been damaged by this a significant amount. We've been damaged by this, and I said yesterday, approximately $35,000 in contract damages. We had lost traffic. We had lost business. You heard my son testify that he spent a great deal of time, approximately $7,500, trying to correct these problems. And with regard to the defamation per se, I ask you to render some kind of a verdict that you think would be fair for yourself if you were in my shoes with that kind of a website.
Ladies and gentlemen of the jury, you're instructed to disregard Mr. Harrison's last statement.
This website was not put on the air for any good purpose, for any informational purpose, or for any help to anyone other than to harm my business and to damage my reputation. A reputation I've worked very hard over the years to develop. The value of that reputation for me is worth an awful lot. I'm asking for damages in the amount of $100,000 for damage to my reputation. And I'm only asking for that amount because I can't ask for a verdict to ask you to stop them from doing what they're doing to me. And if we just get some judgment, that maybe they would think about it the next time they wanted to defame someone, or that they wanted to take some action against somebody online, or that they wanted to cause harm, or to go after someone unwittingly. The statements there were that, essentially I sought these things out, that I seek out these suits. I didn't seek this out. They came after me. I did not want any part of this or anything to do with it. And so I would ask that you exercise your judgment rendering your verdict, and to consider all the evidence and all the testimony that you've heard here over this course. And again, thank you so much for your time, and thank you for your service.
Thank you. Counsel, Mr. Franklin, you wish to do opposed?
I'll vote.
Thank you, counsel. I figured that's when she stood up. I figured that's when she stood up.
Ladies and gentlemen, you heard Mr. Harris and all that he has said. I represent Mr. Franklin. Mr. Harris went on about burden and that Mr. Franklin didn't provide any evidence to you. But Mr. Franklin was the person who was sued, and the burden is on Mr. Harris to convince you that whatever he said or whatever Mr. Franklin did was false. Mr. Harris made comments to you about his honesty and integrity. There were contrary evidence. There were evidence. Mr. Harris testified that he reviewed every complaint that came to the office, either himself or another attorney did that, and that they were sent out and faxed out, and before they were filed with the court, they were all reviewed. You heard Mr. Arturo Sarosa said, who's been there for a long time, both before and after Mr. Harris bought the firm, the business. He said it's not true. He said documents went out. That was not true. You heard him say that you heard Mr. Harris said that fees didn't go up very much. You heard Mr. Sarosa, who was there before and after, who said that it's not true. That the expenses went up substantially, and that people were paying more money for the services they were receiving. You heard him say that the paralegals were the ones who were preparing documents and filing them with the court. Mr. Franklin said, Mr. Harris said, no, that's not true. We review everything. Now, Mr. Harris wants you to think that Mr. Harris, Mr. Franklin, and Mr. Del Casal, they're all liars, and they lie. Mr. Harris told you a lot of stuff, and he said they're not true. Question is, it's a matter of whom do you believe? Mr. Harris is the one who filed a lawsuit here. Who is more likely to tell an untruth to make himself look good? This is his case, and he's asking you to make a decision on his behalf. Find for him. Mr. Harris claimed that Mr. Franklin stole from him. What the testimony was that Mr. Franklin bought the website because it had been abandoned. I believe that both Mr. Harris' son and father testified that they didn't want the website because they wanted to leave that kind of negative energy behind, and therefore they did not use it, they didn't want it. When Mr. Franklin went online to find the website, he discovered that it was for sale and he bought it. Now, there was evidence that Mr. Harris testified that Mr. Franklin transferred, or Mr. Harris's business to the website. Mr. Franklin testified he did not do that. But even assume, ladies and gentlemen, that he had done that. Did you hear from Mr. Harris any evidence as to how much of this caused him problems, how much was transferred to that website? One of the instruction the judge will tell you is that, yes, his business went down, but you have to decide from what he has to prove to you or tell you, from what other, is this the only source? Was this the only reason that his clientele went down, that his business went down? Didn't give you that, did he? Didn't hear that. That, no, there was no other reason that my business went down. It was only because of what Mr. Franklin did in that website. There was no evidence as to that. Threw some monies at you. The testimony was that the monies that was being collected through the office were mainly collected by the paralegals who were there. And they were getting a portion of that. He testified that Mr. Del Casal said he was sharing monies with non-lawyers called unlawful practice of law. That's basically what he was doing. He testified, and you saw his agreement with Mr. Del Casal, that he would pay Mr. Del Casal, for the office part of it, and the rest of it would be paid through the office. And that Mr. Del Casal, excuse me for a second, that Mr. Del Casal would be compensated for his consulting business. When Mr. Del Casal agreed to stay on, that was the agreement, he would be paid from the office. From what monies? Mr. Del Casal testified, uncontradicted, that he, for 18 months while he was there, he was paying the bills. Mr. Harris owned the business. Mr. Sharing the monies with non-lawyers, ethical. Do you figure it out?
Objection, Your Honor.
Mr.
Counsel, a second. Objection.
Counsel is invoking ethics, and that wasn't brought up at all. It's not a cause of action, it's irrelevant.
Sustained. Move on, counsel.
Mr. Harris said that the website that Mr. Franklin put up harmed his business. There was no evidence that this actually harmed his business. Talked about his reputation. He said that Mr. Harris, Mr. Del Casal, and Mr. Franklin did not provide any one evidence or one witness as to the fact that the business was harmed, or they didn't harm the business. Well, he didn't provide any either. His son testified, but remember, it's his son. Don't expect him to testify against his father. As to the theft, Mr. Franklin said, I bought the website. As to conspiracy, Mr. Harris testified that, well, they put on the same website, they talked about things, and Mr. Franklin continued to put things up, and Mr. Harris, Mr. Del Casal, they all put together, and that must be conspiracy. If you talk to friends, is that conspiracy? Because you interact with somebody, is that conspiracy? What evidence was there apart from those possibilities or likely? Likely is not evidence in this case. Mr. Del Casal testified and Mr. Franklin testified. We did not talk about, or we did not collude against Mr. Harris. We didn't talk about his business, or, well, we did, after the lawsuit was filed, we might have, I posted things and he posted things, but there was no collusion. And Mr. Harris did not prove that there was any collusion with Mr. Harris, with Mr. Del Casal. As to defamation, Mr. Franklin testified that the information that he had gotten, he had used the services of Equal Rights for Divorced Fathers prior to Mr. Harris owning it. And when he got the information from this person who asked him to publish, to create, that's what he does, is create websites based on what he knew of the business and his experience with it, that in fact, yes, it's true, most of it. In fact, if you look at that website clearly, a lot of it was opinions. A lot of it were just the various opinions from this person. But Mr. Franklin testified that he took it down soon after it was up because he didn't get paid for it. And so he took it down. Mr. Harris did not give you, he said in here, testimony as to what damage he suffered during that period. What's the amount of damages? How many clients did he lose? How many people talked to him about, I saw this website, I'm not coming there. There were negative reviews of that business after Mr. Harris purchased it in 2014.
Objection, Your Honor. This is assuming facts that have not been entered in court. I'm not aware of what she's talking about.
Counsel?
Mr. Harris operated the business, he bought it in 2014, and the website was put up in 2018. There was testimony that there were negative reviews during that period of time. That's what I'm talking
I'll
about.
allow that.
She said evidence.
I said, never reviews, check, that's negative reviews, not evidence, negative reviews.
Mr. Testimony was that there were negative reviews of the business prior to Mr. Franklin putting up that website and after Mr. Harris bought it. Never told you how many were there or what effect those had, or how much it affected his business at that time versus for the few days Mr. Franklin put up that website. It is his burden to show what his damages were. And the judge would tell you speculation is not it.
Objection, Your Honor. It's calling that you're going to tell the jury something.
Counsel, it's in the jury instruction. She's referring to the jury instruction. It says speculation is not a basis. Go ahead, sit down.
Mr. Franklin testified that, yes, he continued to post about Mr. Harris after the case was filed. He was pissed, he was angry. He said that he felt that Mr. Harris, in those letters that Mr. Harris testified that he sent to him, was trying to get him to perjure himself, to say that Mr. Del Casal was the one who worked with him to create that website. Mr. Harris he really emphasized his reputation and how important it is and to clean up the guy and everything. Why would you attempt to get somebody to say something that's not true? Mr. Del Casal testified that Mr. Harris did not want him to tell anyone that he had bought the business. Honesty. That's what Mr. Harris is selling you, how honest he really is and how this website damaged him and his reputation. It is your burden. It is your responsibility to determine whether or not Mr. Franklin, in putting out this website, really damaged Mr. Harris in any way. I don't think he did. I don't think there's any theft. Mr. Franklin, uncontroverted, said he bought the website. It's available. There's no theft. There is no theft. He said he did not conspire with Mr. Del Casal to do anything. There was no theft. The measure Mr. Franklin wanted to find that his reputation was severely damaged because of all this. You have questions, I have questions. I want to put it to you. Also consider what the other witnesses said, what Mr. Sorosa said about the fact that yes, there were dishonesties going on there after Mr. Harris bought the business. What Mr. Del Casal said, he was there for 18 months afterwards, as to what Mr. Harris did not want to say, and that he was paying the bills while Mr. Harris owned the business. He's a lawyer. He knows the rules. I hope that when you go back to deliberate, you'll find that Mr. Franklin, I keep messing up these names, Mr. Franklin did nothing wrong. And find in his favor. Find for Mr. Harris find for Mr. Franklin. Let me emphasize that, find for Mr. Franklin against Mr. Harris. Thank you.
Good afternoon, ladies and gentlemen. I want to also thank you for spending this time over the last several days on this, and so I do appreciate all your time on this. You know, the court from day one told you that we're here about disagreements. We all have them. We all have disputes and disagreements almost daily. What I want you to think about is how people react to disputes, arguments. It's a very important question. In this case, we found out that Mr. Harris, and he didn't want to tell you this, but he's an arbitrator. He's a dispute resolution specialist. It's called alternative dispute resolution. He didn't want to tell you that when he went over his biography. He did 300 in the hundreds of dispute resolution matters. But in this case, when he saw that website, he got so angry, he didn't even make a phone call to Mr. Del Casal, who he thought was the author. And he just pick up a phone, dial a few digits, and call him up. Hey, Ernie, is this, have a conversation. What took a few moments. In fact, Mr. Harris says his lawsuit caused the website to go down quickly. That was his. So he admits to you that the lawsuit was effective on removing a website. Well, if the lawsuit was effective, then a phone call would have been effective. He could have done a threat letter or threat, hey, Ernie, if you don't take the website down, I'm going to sue you. The website would have went down. But he didn't make a phone call to try to resolve the dispute. So I want you to think about that from the beginning before we go into these claims. A phone call to a friend. Mr. Harris said Mr. Del Casal was his friend and still is his friend, so who doesn't even try to do that? It could have potentially avoided all this. Mr. Harris said he doesn't want to be here. Well, he could have, I think he wanted us to be here. He filed a suit on his own behalf. Turning to the contract itself, this breach of contract, the contract was in March 2014. March 2014. And you all heard that Ernie left in December 2015. Okay, that's almost not quite over a year and a half. And he's trying to tell you that Ernie didn't do something in a year and a half, and they were in the same office, and he didn't turn over something. A year and a half, he's sitting there next to Cam. So the truth is, Mr. Del Casal performed the contract. He went above and beyond the contract. It said just stay there 6 months and help us out. He stayed a year and a half to help them out. So he did not breach the contract. And I apologize, I like to refer to notes occasionally. You know, the contract, and I put it up on the screen, even as a typical notice clause, I think it was paragraph 9, all contracts, say if you have a problem, give me some notes. You didn't see any evidence from Mr. Harris, even an email, saying, hey Ernie, give me a password, or I got a problem here, nothing. If anyone breaches contract, it was Mr. Harris. He shouldn't have sued Mr. Del Casal for these allegations. He didn't make a phone call, he didn't even send an email to say, you know, we got a problem, where's the password? You can't send an email? In regard to the conspiracy, it requires more than one, it requires 2 or more people. You'll see the jury instruction on that, who acted in concert. That's a kind of a, what that means, they had to actually, had an agreement. People have to actually agree to do something. In this case, there is no evidence that Mr. Del Casal and Mr. Ring had some agreement to build a website. We agreed to do it. In fact, Mr. Franklin told you that it was a guy named Ryan. This is no ghost. Mr. Harris wants you to believe this is a phantom. And if he repeats it enough, he hopes that you guys will start believing it. It's a repetition strategy. But Michael Franklin met a person named Ryan. That's his testimony. He's not a ghost. And it seems to me like Ryan backed out. But not only that, but Mr. Franklin said he didn't have a conversation with Ernie before the website went up. And Ernie said he didn't have a conversation with Mr. Franklin before the website up. So there is no conspiracy to create the website. Mr. Del Casal is not an internet specialist. He doesn't know how to create, he doesn't know what a Google listing create. He didn't put anything on Google. So he can't be responsible for diverting website traffic. That wasn't, he didn't own the Google listing, and he doesn't, so he can't be guilty of any theft. Which you'll see in the instructions is also known as conversion. And you know, what's really interesting most of all is we heard evidence from Mr. Harris himself that he also trashed a judge. He defamed a judge, and he didn't care about her reputation one
Objection,
bit.
Your Honor.
Sustained,
Way up.
Counselor,
That is mine.
sustained. Needham.
Your Honor, I move to strike.
Counselor, I sustained your objection.
Then another thing that Mr. Harris didn't tell you the truth about is he said bar complaints are confidential. And he's doing that deliberately because he's trying to say only Del Casal had this information, you know, and it's similar to the website. You'll see differences if you compare it. But truth is, bar complaints are not confidential. As I said in my previously, and once an investigation is completed, it's kind of similar to a police complaint. Once all the police matters, once it's all, the investigation is closed and finalized, people have a tendency to get the records from any government agency. Well, it's just like here, when a bar complaint is closed and the matter is, it's available to the public. So if someone wants to get a bar complaint, they can get one. So he didn't tell you the truth on that. And that's why he didn't hear that in his closing argument, that bar complaints are confidential, because they're not confidential. The person who writes the complaint, they're probably telling all their friends and family about our bar complaint. You know, in the website, this organization was around for years, and they even, Scott Cater told you there was pamphlets in the lobby explaining the whole history of this organization, what it did for people and all that. And you saw the photograph yourself of Ernie Del Casal in the office. It was taken by a Review Journal photographer. Okay, and hundreds of thousands of people went through this organization. You heard Michael, they were all helped. So this information is all over. A lot of people know about it. And there was even pamphlets, like they had meetings, and a lot of people knew about this organization and whatnot. So it's not Ernie who, he communicated this information to many people. You know, there is a difference too on the defamation is versus disparagement. Okay, you'll see an instruction on business disparagement. Okay, and this website, the domain name was ecorightsfordivorcefathers.com. equalrightsfordivorced.org. It wasn't kurtharris.com. So it was really trying to criticize equal rights for divorced fathers. That's what the intent. They saw the before, it was under Ernie's realm, and then an after. People were disappointed. In the opinions of a lot of fathers, they didn't like it the way it turned out to be. Mr. Harris bought a men's club and didn't want a men's club. Doesn't make a lot of sense to me. But that's what he did. And so, of course, that's going to lead to people being disappointed. You buy a men's club and you don't want a men's club, men are going to be disappointed. But that's what he did. So this is a business disparagement. It's not defamation. You know, there is one good news about this, and that is the website was up very small time. 24 hours, Mr. Franklin said. He took it under construction. And that means Mr. Harris's photograph was also taken down in a very short amount of time. So why did he sue Mr. Franklin? He didn't even make a phone call to Mr. Franklin. Again, another phone call to Mr. Franklin. He didn't even pick up the phone and say, hey, I found you. And this is months after the website was taken down. So he didn't really need to sue Mr. Franklin. The problem is he's angry. Angry. And that goes to my very first point about disagreements and disputes. You know, especially when you're a dispute resolution specialist, pick up a phone call and talk to somebody. See if you make an effort. It wouldn't hurt him. Wouldn't hurt. Potentially we would be here today. If you would have made phone calls, we would not be here today. So I ask you, ladies and gentlemen, that you rule in favor of Mr. Del Casal. He didn't breach the contract. He wasn't part of the website. Michael said that. Mr. Del Casal said that. And therefore, he didn't deserve this. He didn't deserve to be here, drugged in here by Mr. Harris. So I ask that you find no liability for Mr. Del Casal. No breach of contract. He wasn't part of the website. There was no conspiracy. So no liability for Mr. Del Casal. Thank you.
Councilor Plaintiff rebuttal.
Thank you, Your Honor. Just want to address a couple of things. And again, thanks so much. I'll try to. But Mr. Needham just lied to you. He called me some kind of dispute resolution specialist. State Bar doesn't allow us to designate ourselves as specialists. Actually, it's unethical and it's improper. I don't know why he would lie about something like that other than he's just desperate at this point. And desperation is really seeping through because they showed up here at trial. They didn't bring one bit of evidence for you to show. Not one piece of paper. And they went over there and they fumbled and bumbled through exhibits the last couple of days. They didn't even print out exhibits. And my counsel, Carrie Doyle, had to show them exhibits that I provided to them over the course of the last 3.5 years. And they don't even bother to print them out. They just come in here all haphazard and decide they're just going to sling mud at me and gaslight you and make a bunch of statements about things that aren't true. Now, he said I lied to you. I don't think bar complaints are public. If it were, why didn't they bring it in here for us to see? Or why didn't they testify that this phantom read it and relied upon it when he used it? That would have been an easy thing to do. He could have actually gone and got it. He could have done something rather than just come in here and bellyache and complain and sling mud. He could have called up the bar and said, hey, show me this public report that's out there. That he could have done that. But rather than do that, he wants to come in here and call me a liar. And that's okay. He's got a right to do that, I guess. And then say I defame people in one thing or another because let's just gaslight you some more and say, I didn't do it, that's what you did. And that's their game, and that's what they've done all along. They've obviously not paid any attention to any of the evidence, and they've not looked at any of it, and they don't even have a copy of it. They show up here without anything, despite the fact that I provided it to them over the course of the last 3.5 years, and a complete copy on June 8th that they didn't even bother to print out. And I had to provide that to them, my counsel did. And you saw that, and it wasted oodles of time for you, for which I am eminently sorry. It should have gone much sooner than that, much quicker. They said Arturo, that's their star witness, Arturo, that's it. The one that used to smoke weed with Ernest at the office was what you heard in the testimony. And then they said we don't have any testimony of lost profits and damages. You heard my son testify at length that he'd spent numerous hours trying to clean up, $7,500. He estimated that we lost maybe 100 or so clients. Over the course of that life, that is about an average of $5,000 per client. Now that goes to attorneys, that goes to the people that work in the office. That's where that money goes, and so it's spread out. But that is an estimate that you have there. You heard that evidence, you heard that testimony. Testimony is evidence, and you get to weigh on the credibility of who hands it over to you. Just coming back, words mean something. Words matter. Words can harm businesses. A good reputation takes a lifetime to build and establish. They are the author. There is of this manifesto. There is no phantom. That was conjured up. That was something they cooked up with, and it's something they cooked up midway through the litigation, as you heard earlier today. At the time of his deposition, he wasn't given any information. That just came up at some later date. It was a new thing that he presented. There's been no evidence, no proof, no documents on their side whatsoever, just argument. Mr. Needham is super hung up on a phone call. And nowhere in the world does it say we're required to make a phone call. And I'm not sure what a phone call would accomplish ever at any time. You can be the judge of that, but I don't understand why he thinks that a phone call is going to help. I've made a lot of phone calls to him over the course of this litigation. Those phone calls didn't help. Here we are. And so none of those phone calls resolved anything in all of those calls. I do want to make the case that I couldn't call this Mr. Franklin guy, the hiding guy behind domains by proxy, which he just said to you I should have, because I had to file the lawsuit to get the subpoena, to subpoena domains by proxy, for them to reveal this guy who didn't want to be found, who was running around secretly in the shadows and up to no good on the web. I'm asking you to hold him accountable for his actions. I'm asking you to hold Defendant Del Casal accountable for the manifesto. There are too many bricks in this wall to overcome. I've asked you, and we ask you to quantify the damages, and we ask you to take our business into consideration and look at the harm that they've done by their actions and their comments and their continued efforts to attack me and my business, even throughout this litigation. And so, Mr. Needham says, hey, a phone call would have fixed this. A lawsuit didn't fix it. They just keep it up. They can't stop. And all I ever wanted them to do was just stop. It was never about money. If I could just make them just stop, believe me, that would have happened a long time ago. But they can't stop. They're unable to control themselves and act like adults and act like a retired person or a professional you would expect to act like human beings. They can't get it done. And therefore, here we are, and I'm asking for money to try and help them realize that they can't do this to people. It's super expensive for us to save our reputations. Due to their extreme conduct, we've had to be here. They've created this. This is their fault. I ask you to hold them responsible. I ask you, for once, make them be accountable for their actions and what they do. Thank you so much. I just want my reputation back. Thank you.
Ladies and gentlemen, due to the late hour on this time period, because the fact is that we have a form that we have to get to you, we're going to break for the evening and come back first thing in the morning with the jury verdict forms in regards to that. However, before we break, one thing that I'm going to do is something a little bit unusual because of the fact that we have to do this is, during this case, of course, you've known that two of you are alternates in this matter. The reason I'm doing this is so those alternates do not have to come back first thing in the morning at 9 o'clock with the rest of the juries. But understand this, the alternates are still a member of the jury. The reason why is if during deliberation something should happen to one of my jurors, to the fact, for example, if someone had to go out because of a medical reason or a family emergency, the other juror or the alternate juror, the first alternate juror, would be pulled back into the deliberations. So what we're going to do is, because we're missing some verdict forms, first thing in the morning is my 8 jurors, as soon as they get here, my marshal is going to escort you right back into the jury deliberation room. You're going to start your deliberations on this case, but because I don't want to have the alternates drive down here and then just return back home, I'm going to announce the alternates in this matter, in this case. Understanding what I'm going to do is, before you get to leave, I'm going to have you actually be escorted after my clerk swears in these 2 officers. It's going to be, those 2 officers are going to get you basically your information so that we get a hold of you. In this case, the alternates in this matter are Mr. and Ms. Madam Clerk, if you would swear in my law clerk and my marshal.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed. So help you God?
Yes.
Okay, if my two alternates would just go with my law clerk real quickly, my marshal will give instructions to the other juror members. We will see you guys back here promptly. Please be here promptly at 9 a.m. because we're going to start deliberation immediately at 9 a.m. Please leave your notebooks behind right now and your jury instructions. When you come in first thing at 9 o'clock in the morning, your notebooks and the jury instructions along with the verdict forms will be with you in the deliberation rooms. What will happen is my marshal will wait for all of you to get here at 9 o'clock and escort you directly to deliberations. We'll see you at 9 a.m. tomorrow morning. All right, counsel, what you need to do this evening is you need to get together, give me verdict forms that are approved. If you cannot approve each other's forms, which I find highly unlikely that you won't be able to approve each other's forms, but if you have an issue with that, then I will see you guys here at 8:30. Otherwise, please produce the forms here at 8:30 for my JEA to make copies for my jury, and then make yourself available. Before each of you leave, attorneys, I need your personal cell numbers and contact numbers in case I can't get you the cell numbers to find you. Please be within 15 minutes of the courthouse. As soon as the deliberation comes in, as soon as the verdict comes in, I will contact you. Also, you need to be available in case the jury has questions. If a juror has a question that I believe needs to be done, what happens is the jury puts that question in writing, hands it to my marshal, brings it in, I review it. I then contact the attorneys. If I believe that we need to bring you down here to answer the question, we bring the attorneys down here. It's not required that your parties be here, but the attorneys have to be here. The jury has to come in, we have to then answer the question, the jury then comes out. So I know some of you guys may be a little bit of ways, but I need you within 15 minutes of the courthouse if you can, so that the jury's not sitting around waiting for you guys to do that. I'll thank you very much for your presentation of the case. We'll await the deliberation of the jury. We'll see you in the morning. Thank you.
Thank you, Your Honor.
Case 18-781-255, Harris versus Del Casal.
Good morning, Judge.
Morning, counsel. Have a seat.
Good morning, Your Honor. Thank you.
All right, counsel, I got, unbelievably, multiple verdict forms that we can't agree on. All right, the very first set that I can tell you that is obviously the ones that the court will allow are the defense verdicts, where it basically says, we are the jury in above title find in favor of the defendant David Del Casal. That's the way a simple defense verdict should be. Same for the one from Mr. Franklin and his company MCNW Marketing. So those three verdict forms that are basically basic defense verdict forms, those are going back to the jury. Now in regards to plaintiff's verdict form, I have a very generic one. It basically says we find for the plaintiffs against, and they have to be separated because they're individual defendants. So we got one that says we find against Ernest Del Casal, we find one that says against Mr. Franklin, and then one that says we find against MCNW, all for the forms of defamation per se, business theft, lost profits, and lost business opportunities. Those are appropriate. Those will go back to the jury. Now the one regarding punitive damage form is the one that we have to deal with. When you deal with punitive damages, first of all, the standard is not preponderance, it's clear and convincing evidence. The standard for punitive damage is always clear and convincing evidence. Did we prove by clear and convincing evidence as to these factors? So the very first one I have is a special verdict form that says, did the plaintiffs Kurt Harris and Kurt Harris Esquire PC prove by preponderance of the evidence that Del Casal published or conspired to publish a defamatory statement? That's fine because that gives you the initial basis for getting it in. If it's answer yes, what damages, if any, apart from punitive damages? That's why I understand what you're doing there, Mr. Harris. It's not apart from, this is where you're seeking punitive damages. So it should read, if you answered yes in question what damages, if any, were proved by clear and convincing evidence not to a reasonable certainty it should be, if you answered yes to question 1, what damages, if any, were proved by clear and convincing evidence as a result of defendant Ernest Del Casal's conduct? And there shouldn't be an award amount there because we haven't got to that point yet. Mentions conduct. Do you find that Nelson engaged in oppressive? No, let's take it out, please. It says, so it should be if you answered yes to number 1, did you find that defendant Ernest Del Casal engaged in oppressive, fraudulent, malicious conduct as to da-da-da? That one's fine. Then it's claims against Michael Franklin. Same one, proved by preponderance. It's not again. That one's for the establishment. We're okay with that. If you answered yes, taking out that 5th section. Then if he acted impressive, then comes down the damage one. So once you say, if you answered yes to that question above, then it should be the actual damage section of it. And the damage section should be what amount do you find for Mr. Harris, Mr. Harris's Esquire, PC? What amount do you find for Kurt Harris and or Kurt Harris's Esquire, PC? As and for punitive damages, and then a blank. I'll make those corrections. I'll have them to the verdict, to the jury.
Oh, yeah, I'll be back.
Thank you, Your Honor.
Okay, so we'll correct those ones. Those are the ones that are going to go out. Any statements the council needs to make on the record in regards to the verdict forms?
Yes, Your Honor. In regard to the verdict form, or the jury instructions, here's an issue. The jury instructions that were handed yesterday, there's no definition. I don't know if it was oversight or intentional, but there's no definition or inadvertent. If there's no definition of clear and convincing
I
evidence.
know, counsel. And again, the burden for doing that is on the attorneys, not the court.
Right.
I'm getting tired of doing attorneys' work in a trial. Okay? Jury instructions are the province of the attorneys. Jury instructions I asked on 4 separate occasions to have them done with a stipulated group and a proposed group. I had to get you guys here 3 separate times asking you to do the exact same thing, and we still had to go back in chambers and I had to rewrite them. And now I don't even get verdict forms that are proper, and I've got a jury coming here in 10 minutes.
Yeah, I think, Your Honor, I think there was one submitted, clear and convincing, and I think it was pulled, because I believe Your Honor said it applies on punitive damages issue. That's what I thought. But one was submitted, I thought. And because the disparagement claim that's in there, the disparagement has a mouse component. So it has a mouse component in the disparagement.
I agree.
Okay.
I agree.
Okay. I thought one was submitted. So I just want to make that note. And in regard to, we had some other ones on, I think they were rejected, but I'm not sure what was on the record. And that was there was some proposed ones on privilege, the absolute privilege, conditional privilege, and public favor. I think the court rejected those.
I rejected those.
And I just
You
want
did
to
not establish that Mr. Harris is a public figure,
I just want to make sure
which
it's
is
on
your
the-
verdict.
Right, just want to make sure it's on the record. And I did submit a proposal, which I believe was rejected. It was on the civil conspiracy. Mine had a burden of proof, clear and convincing, but I believe the court wanted the standard form of civil conspiracy, which doesn't indicate any level of proof at all.
Correct.
And so therefore I submitted, I believe, an additional, just an add-on called civil conspiracy must be proved by clear and convincing evidence. And I don't know if that was rejected or what, but it was submitted as an add-on to that form, because the form doesn't indicate one way or the other on clear and convincing.
Thank you. Anything else?
That's it.
Okay. We'll have a contact for you guys as soon as we get a verdict. I gotta go clean up these verdict forms now.
Thank you, Your Honor.
Sarah, please go up here. Please be seated. Thank you.
All rise for the presence of the jury. All jurors are present.
Please be seated. Counsel stipulate to the presence of the jury.
Yes, Your Honor.
Ladies and gentlemen of the jury, have you chosen a foreperson? And if so, who is that person? Sir, please stand. Sir, have you reached a verdict?
Yes, we have.
Please send the verdict to the marshal. Thank you. You may be seated. Thank you, sir. The clerk will now read the verdict to the jury.
Case A-18-781255, Department 29, Kurt K. Harris Esquire, PC, versus Ernest Del Casal, an individual, Michael Franklin Jr., an individual, MCNW Marketing, an unknown entity or trade name. Verdict for plaintiffs. We, the jury, in the above entitled action, find for plaintiff Kurt Harris and Kurt K. Harris Esquire, PC, and against defendant Ernest Del Casal, on all claims and award and assess the total amount of the plaintiff's damages as follows. Defamation per se / reputational damages, $1,000. Business theft, $0. Lost business opportunities, $4,500. Lost profits, $8,100. Breach of contract, $0. Total, $13,600. Dated this 22nd day of July by Kurt K. Harris Esquire, PC, versus Ernest Del Casal, an individual, Michael Franklin Jr., an individual, MCNW Marketing, an unknown entity or trade name. Verdict for plaintiffs. We, the jury, in the above entitled action, find for plaintiff Kurt Harris and Kurt K. Harris Esquire, PC, and against defendant Michael Franklin in all claims and assess the total amount of plaintiff's damages as follows. Defamation per se, reputational damages, $500. Business theft, $2,250. Lost business opportunities, $2,250. Lost profits, $2,250, totaling the amount of $7,250. Dated this 22nd day of July, 2022 by Foreman. Kurt K. Harris Esquire, PC, versus Ernest Del Casal, an individual, Michael Franklin Jr., an individual, MCNW Marketing, an unknown entity or trade name. Verdict for plaintiffs. We, the jury, in the above entitled action, find for plaintiff Kurt K. Harris and Kurt K. Harris Esquire, PC, and against defendant MCNW Marketing on all claims and assess the plaintiff's damages as follow. Defamation per se, reputational damages, $500. Business theft, $0. Lost business opportunities, $0. Lost profits, $0, totaling $500. Dated this 22nd day of July, 2022 by Foreman. Special verdict form. Claims against defendant Michael Franklin Jr. 1. Have plaintiffs established by clear and convincing evidence that defendant Michael Franklin Jr. engaged in malicious or oppressive conduct against plaintiff Kurt Harris, PC. Answer, yes. We, the jury, award punitive damages against defendant Michael Franklin Jr. in the following amount, $5,000. Dated this 22nd day of July, 2022. Foreman. Special verdict form. Claims against defendant MCNW Marketing. 1. Have plaintiffs established by clear and convincing evidence that defendant MCNW Marketing engaged in malicious or oppressive conduct against plaintiff Kurt Harris, PC. No. Dated 22nd day of July, 2022. Foreman. Special verdict form. Claims against defendant Ernest Del Casal. Have plaintiffs established by clear and convincing evidence that defendant Ernest Del Casal engaged in malicious or oppressive conduct against plaintiff Kurt Harris, PC. Yes. We, the jury, award punitive damages against defendant Ernest Del Casal and the following amount, $5,000. Dated 22nd day of July, 2022. Foreman.
Thank you, Madam Clerk. Does either party wish to have the jury polled?
No, Your Honor.
No, Your Honor.
Okay. The verdict will here will be recorded in the minutes of the court. Ladies and gentlemen, I want to thank you for your attention and your time in this matter. what's gonna happen now is I'm gonna meet with you guys back in the jury deliberation just briefly, in order to answer any questions you have. After which time, if either of the attorneys wish to speak with you, they may be out in the hallways. Please understand you're under absolutely no obligation to speak with them. But I would ask you, if in fact they do have questions for you, they will not ask you questions about your verdict. They will not ask you how you came about your verdict. But in every day in our profession, we have a tendency to kind of want constructive criticism. How well did I do? What could I have done differently? Whether your job is like my first job, delivering papers, or your job as a judge, you like to get constructive criticism. So if you have the availability and they ask questions about their performance, you're not obligated to, but you can answer questions of them. The next question I always get asked is, Judge, can we now talk about the case? Yes, you are free to talk about the case. Again, you're not required to. I'm sure somebody might have questions for you, how the jury went or went like that. Again, it's up to you as to whether or not you talk to about it. That's totally up to your free will. Like I said, these attorneys, if you tell them, no, I don't want to speak about it, trust me, they're not going to bug you. They're not going to follow you down in your elevator. But like I said, all of us like to get constructive criticism about our performance. So if you have the availability, please make yourself available. I'll meet you guys right back in the room. Thank you. Thank you, everyone.
Oh my God, you too?